American Giant makes great clothing, sweatshirts, jeans, and more right here in the U.S. Visit American-Giant.com and get 20% off your first order with code STAPLE20. That's 20% off your first order at American-Giant.com, code STAPLE20.
I'm Alice.
And I'm Brett.
And this is the Prosecutor's Legal Briefs. Welcome back to the Prosecutor's Legal Briefs. I'm your host, Alice, and I'm joined, as always, by my eminent co-host, Brett.
Oh, you know, I like that. It sounds like I'm special and important.
You're not. You're not at all. You're not at all. I had to bring him down from the clouds because, guys, yes, Brett's eminent. He's amazing. He's all the great things, but you all know I love puns, and that was just the perfect descriptor because today we are talking about eminent domain.
Eminent domain, yes. And you know, we're going to talk about today a case that brings people together. There have been more controversial cases, without question. There are more famous cases, without question. I don't know if there is a more universally hated Supreme Court case than the one from the last, I don't know, 100
Century?
years. So it's like Korematsu, really? Probably.
Korematsu, but like it's funny because like everyone knows that Korematsu was just so wrong, whereas Kelo, like, it hasn't been overturned, you know? So
right. It's
like still there. And, you know, in reading, and this is an older, I mean, it's like not a case from this season, on this season of Scrotus. It's not from this term or even the last decade, but it's one of those cases where when I went back to read it for this episode, I was mad the whole time, even though I knew the outcome. So you guys get ready because it affects all of us. And you'll see why, you know, you'll understand why the court did what it did, but you'll also see how sometimes those who perhaps live in ivory towers or pie in the sky get it completely wrong when the rubber hits the road and the law meets real life.
Yeah, and this is one, Alice was talking about how mad this made her. This is one that I was in law school when it came out and just remember thinking, this is just the worst thing I've ever read. But, you know, unless you're a complete nerd, you probably have never even heard of this case. You may remember it vaguely because it did actually cause a stir, despite being about one of the more esoteric and sort of nerdy areas of the law. So we're going to tell you a little bit about it, and you can decide for yourself with our heavy bias against it, whether or not you think
it's not just our bias. It's like a universal bias against it.
Yeah. This is one,
including the justice who wrote it.
This is one of those that, you know, oftentimes you don't really get to see the effect of a Supreme Court decision because the lower courts have to sort of figure it out, and the Supreme Court doesn't really tell you much, and it's actually much narrower than you think it is or than it's reported to be. This one, there were consequences, and you're going to see what they were. So let's take you back all the way to 2000. In the year 2000, only some people are going to get that. The city of New London, Connecticut, announced a plan to revitalize their city, increase tax revenues, and bring in new jobs. Sounds fantastic, right? They would build...
What could go wrong, Brett?
What could go wrong? That's the perfect civic project. They would build an economic redevelopment zone and, with attractive tax incentives and low rents, attract new businesses. They had their eyes on one business in particular. You may have heard of it, Pfizer. The plan was to build a small urban village, a revitalized waterfront, new residents, and a 90,000 square foot research and development facility, which would create thousands of jobs. Sounds amazing, but there was just one problem. The land they wanted to build all this on, well, it wasn't empty. People already lived there, and they were not interested in selling. So, New London got creative. They used the power of eminent domain to take the homes and businesses from the people who lived in the area with the intention of turning the land on which they were built over to Pfizer and the developers.
So this may be something that you've heard of before. Maybe it even happens in your own town. Maybe there's kind of a rundown part of town and the business council of the cities, like, we have a revitalization plan. This is going to be great for the city. The thing is, typically when you have those revitalization plans, it's going to be like in the midst of burned out buildings. Nobody lives there. It's been abandoned. It's like the broken window theory, right? Maybe it was an old factory that now is abandoned, or an old apartment complex that's now abandoned, and now it's become a hotbed of illegal activity because people know it's abandoned. And so the city's like, we got to do something about this empty building or this empty, parking lot. What better than to put businesses in there to replace these broken windows where illicit activities are happening and turn it into revenue for the city? How great, right? Now, Brett mentioned something really important about New London, though, because everything they had planned for this Pfizer development sounds great. Who doesn't want thousands of jobs? New London, Connecticut, like the rest of Connecticut, is not that big. So this could really be a boon for the city. But like he said, people lived where the city wanted to build this development. In fact, the residents who lived there, some of who had been in their homes for 80 years, they weren't going to just sit by and let the government take their land. I mean, how un-American is that, right? We've all heard of due process. We've heard how the government can't do takings. They can't just come and take your stuff without some amount of due process. So they fought back. And they relied on the protections of the Constitution, specifically the Fifth Amendment, which concludes, quote, "Nor shall private property be taken for public use without just compensation." Seems pretty clear. Now, the argument for New London was novel, though. Ordinarily, eminent domain, like we said, is going to be used for pure public use. Something like a right-of-ways for roads or power lines, things of that nature. You might even have an eminent domain piece on your land. I have it in my backyard. There's like a sewage line, and you have to walk through my property to actually get to like the manhole if you were ever going to work on it. So the city has eminent domain in order to reach that manhole in my backyard, but they don't take over my whole backyard or even my property, right? So it's usually something like that. If you're driving down the highway, you may see those like power lines cut through forests, right? It's all forest, and then all of a sudden there's a strip in the middle and there's power lines. A lot of that is eminent domain. Now, the government took property for government use for public use, but here the government complicates things because the property would be used privately. But the city tries to come up with this argument, and they explain that it would benefit the public through higher tax dollars and more opportunity, and that, they argued, was good enough. That's good enough to kind of hit the public use aspect that eminent domain has typically been used for. Now, this wasn't entirely unheard of. There's precedent for taking abandoned, blighted properties, redeveloping them for the benefit of the public. But this particular use was going to be different. New London, in this area, it wasn't blighted. Now, they may not have been the highest income or the most value possible, but people still lived there. It wasn't abandoned. It wasn't like a zombie land. People worked there. They raised their kids there. Generations were raised there, in fact. But that didn't stop the government from claiming that they could take the land anyway.
And this is a really important distinction, because this idea of removing blight is going to be one of the bases on which the Supreme Court decides this case. But it's really important to think of property and what it means to own property and the responsibilities for owning property going back as far as you can think to when the first time people really conceptualized what property is. There's always been this understanding that property owners, you own something, but you also have a responsibility. So, for instance, you may have heard of things like adverse possession. And the notion of adverse possession is if you have a whole bunch of land and somebody moves in on it and lives there, and you know they're there and you don't do anything about it, and they're there for 20 years, at some point, that land is just going to become theirs. And you can't say, wait, that was my property. The idea behind this is, yes, we want you to have property, but we want you to use it responsibly. We want you to put it to good use. Blighted properties are similar. You have these properties where, yes, someone owns them, but they've essentially abandoned them. They're not taking care of them. They've let them collapse. As Alice said, they've let negative elements move in, and crime is being committed there, and it's not safe. And it's not a neighborhood anymore, and there aren't businesses there anymore. It's not your little neighborhood. Man, if we put a skyscraper there, wouldn't that be a better use of where your house is? You've basically abandoned your property right. So we are going to take that, and it will end up in private hands, and those hands will then be able to redevelop it. That is the starting point for this, but the huge logical leap between, well, we can take property like that and give it to private people. So what's the difference between taking property that's been abandoned and that is now blighted and filled with crime, and the owner, we don't know who it is? What's the difference between that and somebody who's lived in their house for 80 years? Because we can get more tax dollars out of that property if we just give it to somebody else. There's a massive logical leap between those two, but that is going to be one of the bases for the Supreme Court's decision that we're going to see. And the Kelo plaintiffs, they take this on directly. They say, look, this isn't just a novel legal argument. It's one that has no limit. If it's accepted, then government would be able to take property for really any reason at all, as long as they can offer some ephemeral benefit to the public, even if that benefit was only a potential increase in property taxes. And the government could do that even if it meant taking property from ordinary citizens and handing it over to corporations. Now, you might think to yourself, why would anyone think the Fifth Amendment would allow that? Surely, if the Fifth Amendment was created for any purpose, it was to prevent something like this. And yet, as this works its way through the courts, court after court after court says it's okay. Eventually, at first, it's going through the state courts. And in a close 4-3 decision, the Connecticut Supreme Court says, yep, absolutely. This taking violates neither the Connecticut nor the United States Constitution. And that means there's only one avenue left. So, as we've talked about before, you have federal courts and you have state courts. And there are federal district courts and federal appeals courts. But when your case is in state courts, when it starts in a state court and it sort of works its way up to the state Supreme Court, you don't appeal that to the federal district court. They don't have jurisdiction over it. The circuit court over your state and over multiple states, they don't have jurisdiction over it either. The only court that can overturn a state Supreme Court is the United States Supreme Court. So if these people are going to get relief from this, they're going to have to go to the Supreme Court. They do that, and the Supreme Court takes the case. But if they hoped that the High Court would save their homes from a corporate takeover, they were in for a massive disappointment.
Again, I know where this story is going. This is a tale of 24 years old, and I still get sad talking about it. Because many of you you've been listening to us for a while, you've read the Constitution, or at least you've heard us talk about the Constitution enough. You must be thinking, of course, the Supreme Court is going to overturn the Connecticut Supreme Court. But actually, in a 5-4 decision, the Supreme Court agreed with New London. They said nothing in the Constitution prevented a government from taking the homes of ordinary people, all of you sitting in your homes right now, think how this affects you, and giving that property to a corporate entity that, in the government's view, could put the land to better and more profitable use. Justice John Paul Stevens, who's no longer on the bench, wrote the majority for this case. And the majority was joined by Justice Anthony Kennedy, David Souter, Ruth Bader Ginsburg, and Stephen Breyer. Actually, none of them are on the bench anymore. It's amazing because
it is amazing, actually.
24 years, like 2000 doesn't seem that long ago to me. And as I'm reading those names, I'm like, oh, this is all history now, but I'm history.
Yeah.
I'm so old. It's a totally new bench from the one that decided. Well, not completely new bench. Just the majority is completely new.
Well, there's seven new justices from this case.
That's a lot.
Yeah.
That's a lot of new justices.
I know, 8 new justices.
What?
There's 8 new justices.
Is it Clarence Thomas the only one?
I think Thomas is the only one. Yeah.
He's the only one because he's like now
Wow.
the longest serving.
That's crazy.
I know, we are old. I'm sorry. This is a complete tangent that has nothing to do with any of you or Kelo. It just has to do with our realization that we are marching closer towards death.
There you go.
You just saw a midlife crisis happen in real time, guys. Okay, back to the issue at hand that we're talking about, eminent domain. Sorry, guys. We just really realized. I saw all the justices flash before my eyes and realized that we are closer to the grave than not. Anyways, so
yeah, leave it all.
You might be thinking, what did Stevens rely on for this opinion? Because it seems like a bit of a reach. All of us sitting in our homes right now, wherever you are, or maybe not the coffee shop, but like you're saying that someone can come in and just say, it would do better if it were a Target. There's no Target in this town. If we take your home, this might be your closet. It might be your podcast studio. It might be where you raise your 3 kids. It might be where you eat and enjoy time with family and friends. Doesn't matter. We can bring in higher revenue if we can turn your house into a Target instead. You're saying the Supreme Court agrees that you can do that? So how did he reach that decision? So the camel nose under the tent that Stevens relied on was a case called Hawaii versus Midkiff. And this was a case in which the Supreme Court had blessed the use of eminent domain to break up the high concentration of land ownership in Hawaii. Now, this obviously resulted in private property being shuffled around from one private owner to another. And this was all the precedent that Stevens needed to argue that this wasn't a novel theory at all. It was one that followed naturally from the Hawaii case. Some of you may be thinking, I don't live in Hawaii. Hawaii is very different.
And you see this often. One of the reasons we love talking about this and we enjoy this is if you go all the way back to the founding of the country and the Federalist Papers, I think it was Alexander Hamilton who wrote that the courts, they have no power on their own. They have no standing armies. They have no authority to do anything. All they have is the power of their reasoning. And their reasoning is, at the end of the day, why their opinions continue to have influence. And so when you see an opinion like this and a court is making an argument, there's a reason they don't just say, held, Connecticut can take the property and give it to somebody else. There's a reason they don't do that, because they want to give you the logical, legal, historical, constitutional reasoning for what they're doing. And here, the justice is attempting to build this sort of chain where it's like, look, 1 happened, and then 2 happened, and then 3 happened. And what follows 3? 4. And that's where we are here. So this is perfectly logical. This isn't an extension at all. This has always been what eminent domain meant. We're just now getting to sort of explaining that, right? But the problem is, as Alice said, we've already noted for you one area of eminent domain that is very different, the blight type situation and the logical leap you have there. Midkiff is even worse in a lot of ways because Stephen just ignores the unique circumstances in Hawaii. The principle was there, and that was enough for him. He was going to take that principle and spin it out into this larger idea. He wrote that, and this is the kind of sentence that should concern you, because this is the kind of thing that if it's applied widely means you don't actually have any rights. You have whatever you think you have now, but we're one change away, one need away from that right going away. And here's what he says. Stevens wrote that the needs of society have varied between different parts of the nation, just as they have evolved over time in response to changed circumstances. Thus, whatever protection the Takings Clause had offered to ordinary citizens when it was ratified, or for the first couple hundred years of the Constitution, that protection, Stevens argued, must give way to what society needed now. The Constitution had evolved, and that evolution took the power to seize private property for public use and converted it into a power to transfer private property from homeowners to Pfizer on the basis that the enlightened judgment of the government was that it would benefit everyone in the end.
That scares me. Enlightened judgment of the government.
Yeah, well, what are you going to do?
And I say this because you have to think about, obviously now we have hindsight, and we'll go into what hindsight has shown us. But it honestly, and look, Stevens was a very nice man, but he would tend to speak like this in kind of loftier terms and very professorial. And it's these like pie in the sky ideas that I think really cause problems when you apply them to real life here. So, as you may imagine, this opinion resulted in 2 strident dissents. The chief dissent was by Justice O'Connor, which William Rehnquist, Antonin Scalia, and Clarence Thomas joined. Justice O'Connor began by citing one of the first Supreme Court opinions, Calder versus Bull, in which the court wrote, quote, "A law that takes property from A and gives it to B, it is against all reason and justice for a people to entrust a legislature with such powers, and therefore it cannot be presumed that they have done it." O'Connor was very familiar with this case that Stevens relied on, Hawaii versus Midkiff, because she wrote it. Now, O'Connor noted that at the time of Midkiff, quote, "the state and federal governments owned nearly 49% of the state's land, and another 47% was in the hands of only 72 private landowners. Clearly not the kind of case that should have been used to justify such an expansive use of the eminent domain power." By the way, this is a very good example of how these opinions take on a life of their own. O'Connor wrote Midkiff, but it's not like she gets to dictate how it's then applied. That's why clear legal writing and legal analysis is so important, because your own words, in this case, O'Connor's own words, are being used to reach an outcome that she completely disagrees with. And she's like, that's not what I meant in Midkiff. That's not what Midkiff stands for. It doesn't matter. O'Connor doesn't own Midkiff or the reasoning in Midkiff just because she authored it. It is the opinion of the court. And those of you who joke that lawyers are such sticklers for grammar and words, this is why, because words are powerful. And in this instance, O'Connor's like, you have completely changed the meaning of Midkiff, but she has no extra power over the rest of the court just because she wrote that opinion. Now, O'Connor then goes on to write, in conclusion, in this strident dissent, quote, "Any property may now be taken for the benefit of another private party, but the fallout from the decision will not be random. The beneficiaries are likely to be those citizens with disproportionate influence and power in the political process, including large corporations and development firms. As for the victims, the government now has license to transfer property from those with fewer resources to those with more. The founders cannot have intended this perverse result." And I don't think this is hyperbolic. I think O'Connor hit the nail on the head. That's exactly what Kelo does, because we know that power goes to those who have the means. And so when there is this reasoning that essentially the government can give any reason to take things from someone, they're not going to take it probably from the billionaires. They're going to take it from the Kelos, from you and me, right? People who are just Joe Schmoes sitting in their houses who don't own massive corporations or, billions of dollars. And that's why the Constitution exists, to protect that imbalance of power. And O'Connor says that protection against really those who are powerless in the face of either money or the government, that protection has been eviscerated because of this opinion.
But whatever O'Connor's arguments, the deed was done at that point. The plaintiffs, including that 80-something-year-old woman who had lived in her home since the day she was born, lost, and that meant they were going to lose their property as well. Initially, the city of New London even tried to charge them for the extra time they had spent on their property while the litigation was pending. They were encouraged by the state government to drop that, and they did. And that was probably wise to do so, because the reaction to Kelo was as swift as it was universal. It was condemned roundly from every corner of the political spectrum. Rarely does a Supreme Court decision especially one on a relatively esoteric question, would the divided court result in such approbation? The AARP, the NAACP, the Libertarian Party, and the American Conservative Union, just to name a few, groups that you don't often see all together on any particular issue, condemned the ruling. And that condemnation actually had some positive results. Before Kelo, only 8 states prohibited eminent domain for so-called economic development. By 2020, 45 states prohibited it, with 12 states going so far as to amend their constitutions to enshrine that prohibition in their constitutions for all time.
By the way, this should be heartening to you all. This is exactly what's supposed to happen if you don't like a court ruling. The legislature is supposed to take action, right? So as like opposed to this decision as we are, and really as it sounds like just about everybody was, this is actually the way checks and balances is supposed to work. In this case, it was the states acting against what the Supreme Court does. But really the legislature can act and should act whenever there is a ruling by a court that the people, who elect their officials, who represent them in the legislature, don't agree with. And oftentimes we don't see such swift action, but I think this just shows you how strongly people felt about it. Now, some of you may be wondering, and I hope you are, because New London is a real place and real people live there. What happened in New London? Because even if all these other states passed laws against eminent domain for economic development, that wasn't going to help New London in this case. Tens of millions of city and state dollars went into this massive revitalization project in New London. And despite receiving the property for just $1, that really hurts my heart that that's all they got for it. The developer was actually never able to secure the financing necessary to develop the area. So Pfizer would close its facility in 2010, resulting in thousands of lost jobs. And in 2011, one of the Connecticut justices who had joined that original 4-3 decision that ended up sending the issue to the Supreme Court, they actually came out and apologized for the decision. The city of New London joined him, apologizing to Suzette Kelo and her neighbors who had fought them in court. You never see that either, by the way, an apology.
And by the way, Pfizer was gone 5 years later. If this all happened in 2004, 2005, and they were gone by then, 6 years, in 2011, you're having these apologies. I mean, you talk about it didn't take long to see that not only was this a constitutionally infirm decision, an offensive decision, but it was one that absolutely failed to accomplish even the goal that the city of New London had set out for themselves. And by 2010, this area that had once been a neighborhood, that had once had businesses and stores and family homes and people who had lived there for 100 years, it was just a vacant lot. That was all that remained. Nothing else. What had once produced property tax revenue for the city now produced not even that. In 2011, the city finally found a use for the property as a dump for debris from a hurricane. That same year, Justice Stevens would release his memoir. In it, he makes no mention of Kelo.
This case makes me really sad.
Yeah, it made me sad when it came out. It made me mad. I would say this case, like I said, I was in law school. You were probably a little bit behind me, but I was in law school, so this was one that when it came out, it shocked me. I wrote my law school note on this for the journal that I was on. If you're in law school, you can write sort of an article for legal reviews. It's like one of the things you can do. And I wrote it on this case. Actually wrote a song about this.
You wrote a song about this?
I wrote a song about this.
You are going to sing it tonight, right?
I don't know if I'm going to sing it. It was called Day O, the Banana Court song, and it was set to the Day O, Sandra Day O, Kelo come and they taken my home. Day Sandra Day, Sandra Day, Sandra Day O. Kelo come and they taking my home. Like that. Then it was like, thought the court saved my childhood home. Too bad team needs another dome. Like that. I'll tell you what I'll do. I will get the lyrics.
Please keep going. Please keep going.
I don't remember all the lyrics.
The reason I haven't said anything is I really want to hear it all. Where did you sing this song?
I just, I was inspired. Sometimes injustice results in great art. It was like, poor man, little man takes the punch. Pfizer, Walmart, get free lunch. Something like that. But what I'll do, I will find...
Brett, this is like, how did I not know you did this, and why is this not released on Spotify?
I'll tell you what I'll do. I'll find the song, the lyrics, and I'll post them. And you guys out there who are actually musically talented, you can create a version of it, and we'll release it to the public if I can find
Brett,
the lyrics.
There is no guile here. I've never been more proud of you in my life. This may be the most proud I've ever been of you, and we've tried many cases together. You have stood up for the little man before, but right now I am so proud of you. I give up.
Yeah.
You win everything today.
Yeah, I don't know why it took us so long to do this case, because like I said, this case definitely inspired a lot. You wrote a song about this case
and we didn't start legal briefs with Kelo? That could have been our song.
And I'll say this. Kelo is one of those cases, as Alice pointed out. We have 8 new justices. And honestly, I wonder if any of those justices would have sided with the state. I honestly don't know. I feel like if Kelo came up again, if there was a new case, which I don't know if there ever will be a case like Kelo, because 45 states have prohibited basically this same thing. But if it comes up again in this court, I have no doubt that Kelo would be overturned. I think Kelo is easily one of the worst decisions, universally regarded as one of the worst decisions of the last 100 years. No one is out there fighting for Kelo. I don't care what your view of the Constitution is, how you think it should be interpreted.
There are so many different ways that people are opposed to Kelo. Like, you may disagree on the actual reasoning, but everyone agrees that it's terrible.
Yeah, like if you're sort of an originalist, you probably would say there's, as O'Connor wrote, going all the way back to the very early court, like pre-1800 court decisions, there's no way this is what this means. And if you're sort of more of a living constitutionalist honestly, this is kind of a living constitutionalist decision if you listen to what Justice Stevens said. But I think the way it would be looked at now is we need more protections for average people against sort of things like this, taking property and handing it over to somebody else, than ever before.
I think O'Connor really nails it on the head when it seems so un-American. That's the thing that I think everyone just kind of bristled at, right? She literally says, it's against all reason and justice for a people to entrust a legislature with such powers. She's saying no one would have ever founded a government that allowed the legislature to do something like this, because it would be so counter to their own interests that there's just absolutely no way our government was written by people to basically take away all their rights in this way. You have to have a dictator come in. And she's essentially saying that's what this opinion is. It's the dictator that's overruling all of the democratic government that we wrote through our founding fathers.
It's one of those, if the Constitution means anything, it means
it has to mean this.
You can't take my house and give it to a corporation because you hope that they'll pay a few more taxes than what I'm paying. They can't mean that.
Just extrapolate this out, right? I see Brett at lunch, and I slap his lunch out of quite literally slap his lunch out of his hands and take his wallet and give it to the homeless man next to him. Be like, well, he should get it.
It's even worse. It would be like if you slapped my wallet out of my hand and then gave it to Bill Gates.
Yeah.
At least you have some sort of Robin Hood argument when you do that. But this is literally
and then you say it's because Bill Gates, by collecting everyone else's wallets, now has concentrated power and can give back should he choose to do so.
Should he choose to do so?
He doesn't even have to do so.
Pfizer wasn't required to do anything.
No, not at all. They could have hired, for example, this is pretty relevant today. they didn't have to hire new London residents. They could have imported people from another country, all for all the thousands of jobs, right? And then because of maybe the way their visas worked, maybe none of the tax benefit actually even went to New London. Certainly not to Suzette Kelo. She didn't benefit from this at all.
Or they could, or they could just do what they did, which is like, thanks for the offer, but we're going to have it.
Never mind. I don't want it. But, it's too late, Suzette, because you need to vacate your 80-year-old house.
Right, because we've already bulldozed all the homes. Like, sorry about that. We already did that part. We already destroyed the homes that you lived in for all these years. Well, we have the slab. It's right here. You can build on it. But
we have the slab.
I mean, it's just wild. It's just wild that this case ever happened. I mean, it's incredible that it ever happened. And I hope one day it is overturned, because it needs to be overturned. Even if they overturned Korematsu in like an aside. It was like they had an opportunity to overturn Korematsu, which, by the way, if you don't know about Korematsu, so basically at the beginning of World War II, after Pearl Harbor, the president at the time, Franklin Roosevelt, issued an executive order under his war powers forcing all Japanese Americans, even Japanese Americans who had been born in the United States, essentially, I mean, I'm not going to call them concentration camps because you think of the Nazis. I forget what they called them, relocation camps. I mean, whatever. They put all these people who were American citizens into these camps, essentially under guard. A lot of times, they also, in many cases, lost their properties. I mean, it's just a huge tragedy, a terrible thing, absolute injustice, just completely illegal, unlawful, unconstitutional, unjust. I mean, there are no words to describe it. It goes up to the Supreme Court, and the Supreme Court basically says, sorry, war power, they can do whatever they want, basically. And it didn't take long at all for people to realize how awful this was, and it's been repudiated for decades, but the Supreme Court never overturned it. So it remained good law. It was technically good law. And the Supreme Court, in a case, and I'm not even sure which one it was, but it was like they just sort of had an opportunity, and they were like, I mean, literally in like 2 sentences, oh, by the way, Korematsu, overturned. And then moved on. And so hopefully
they'll do that here. Even just like, we don't even need a long opinion. We literally just be like, it was an oopsie daisy, sorry. We all know it was wrong.
Right. Internment camps is what they call them. People in the chat reminded me. That's what they call them. Internment camps. But I mean, essentially, they were prisons, right? I mean,
they were prisons.
I don't know.
Due process based on profiling. Like, truly.
Honestly, I don't know enough about that time in history. It's another time in history we just don't really teach in school. We know about it. Like, I know it happened, but I don't really know the details, the conditions, or anything like that. It's obviously, as I said, I don't know of anyone who would defend Korematsu. And now it's no longer good law. And hopefully Kelo one day won't be good law either.
I can't believe it, but we might have done a brief legal briefs for one. Because this is so easy. But we should answer probably some questions, because I got all fired up about Kelo. Eminent domain,
y'all. Let's answer
y'all.
some questions. Let's do it. Okay. Remember, if you leave a 5-star review on this podcast or on the main podcast and put in a question, we will answer it for you. So here's one that I think is interesting. This is from P Drink. P Drink wants to know, have you ever thought of or worked on an investigation in such as FBI or other investigative agency, or have you wanted to but missed the opportunity? There was definitely a time where I thought about joining the FBI. I thought that would be really cool, doing that sort of thing. And now, having worked with the FBI in a lot of cases, I still think it would have been fun. What I didn't realize, and what they never tell you, it's like every job, right, is how much report writing there is.
I was going to say paperwork.
There's just so much paperwork.
So little action.
Yeah. I mean, for every action, there's like 5 pieces of paperwork.
If not, no. I think the FBI is probably the most papered of all of the alphabet agencies, actually, that we work with. That's actually, I think, pretty accurate, which makes sense. We've talked about how important report writing is, whatnot. But I remember I was a summer intern for a judge, and we got like speakers at the courthouse. And one of the speakers was an FBI agent who went to law school, wasn't a lawyer for FBI, was an agent for FBI, which that happens. So did like investigative work, not legal work for the FBI. And I was like, this person is the coolest person ever. I was like, yes, that is my career path. I want to be an FBI agent. And then I realized that's probably not my strength. So
I think you would have
Because
been
then we went
amazing.
shooting with the FBI agent, like target practice, and I was really bad at it. And I was like, I don't know that anyone's really gonna respond to me. I'm not sure I want to lead the SWAT team. So maybe I just be the lawyer.
So there was a movie in the 80s, maybe early 90s, I'm not sure. It was about two women who went to the FBI Academy. I haven't seen this movie in probably 30 years, but I remember seeing it as a kid a couple times and thinking it was great. It was about two women who went to the FBI Academy, and I think one of them was like a military veteran. She was in great shape. She could shoot, like you were talking about, but she wasn't really good on the tests and everything, the intellectual side. And her roommate at the FBI Academy was this very nerdy girl who, she couldn't do a push-up. She was terrible at all the physical stuff, but she was really good at all the tests and everything else. And of course, these two mismatched people who didn't really want to be roommates end up joining together to get through the FBI Academy. And so you could have done that, Alice.
You know what movie you're describing nowadays, which is a fantastic movie? Spy with Melissa McCarthy.
No, I haven't seen it.
Oh, it's a fantastic movie. I think it's the CIA technically, but I love Melissa McCarthy. Is that her name? Melissa McCarthy? She plays Suki in Gilmore Girls. Also a fantastic show. Anyways, that sounds a lot like Spy, except it's like, slapstick comedy, and she is already at the CIA. Anyways, great question. I think we ended up exactly where we were supposed to be, which is talking about Kelo to a bunch of people who may not care about eminent domain.
Yeah, exactly. Yeah, if we'd been FBI agents, you wouldn't have this amazing podcast. Okay, I got one more I'm going to ask because I don't actually understand this question, so I'm hoping you can help me with it. This is from Grady Seasons, and I assume they're talking about the titles to our podcast episodes, but they say apologies in advance, which, by the way, much like not to offend you or with all due respect.
Or bless your heart.
Bless your heart. But whenever you start off that way, whatever comes afterwards is going to be an insult. It's going to require an apology, for instance. So they say, apologies in advance, but why is Brett so bad at titles?
What?
Yeah, I mean...
I don't know what that means.
The titles are awful. Are you
like
just
the
bad
titles.
at titles, or are you playing a smart game and making terrible titles on purpose? Okay, so the titles of every episode. I mean, number
They're
one.
songs.
Okay, yes, they are songs. So there's a song. So in episode 1 of every series, or if there's only one episode, there's always a song title. Now, I don't know why I decided to do this. Just when we first started, I think I was, we did Elisa Lamb, and the Dave Matthews song "Don't Drink the Water" was stuck in my head, and so I was like, I'm going to start doing just song titles with every episode. We should do a Spotify channel actually that has like
That actually would be
all the
pretty
songs from everything. Anyways, and I try and think about either the title itself is related in some way to the case. Like for Karen Reed, it was "Dirty Water," which is a song about Boston, or the lyrics are like Maura Murray was "Flock of Seagulls ran so far away." I mean, anyways. And then, but the really hard part is you want in that title to convey enough information to some random person that they're going to click on it. So you have to decide, like, what am I going to say? So for instance, Adnan Syed, I would much prefer to call that the Hae Min Lee case because I like to put the emphasis on the victim. But here's the thing. You have to confront reality. And reality is, most people think of that as the Adnan Syed case. And if you put the Hae Min Lee case, there are going to be a lot of people who see that and they're like, I've never heard of that. And they'll just keep going, right? And you don't want that. So in that one, it ended up being like Adnan Syed and the murder of Hae Min Lee. So it's a very long title, but it gets both of them in there. And so thinking about how to do that to both describe the case in a way that's recognizable, I mean, that takes a little time. So I'm just going to say, I think the episode titles are good.
I think the episode titles are awesome.
Yeah. So.
And
so
also,
there.
it takes a lot of effort, y'all.
It does.
But everyone is welcome to their opinions. And Grady,
Exactly.
you are welcome to your opinion.
By the way, if you're joining us here tonight, I'm just going to go ahead and do a little ad right now. I'm drinking a Santa Lucia Highlands Pinot Noir, which I got.
You're drinking it out of a coffee mug?
First Leaf. Hold on, Alice. Let me do my thing. First
Sorry,
Leaf.
do
If
First
you would
Leaf.
like one, go to tryfirstleaf.com/prosecute for 50% off. And I am drinking it out of a coffee mug. I got this coffee mug actually from the Y-Files, which is one of my favorite YouTube channels. I talked about that before. It says it's obviously aliens, and it has hecklefish on it. So
Yeah.
who wants to drink wine out of a wine glass? It's so like
Definitely not you.
hard to hold on to.
Okay. Brett, I've recorded like 10 episodes this week. I love it. I love recording with you.
This is Alice, by the way, bragging once again about
I'm
having
not.
2 other podcasts. If you're not listening to them, you should.
I'm
City
not bragging.
Confidential and American Justice.
I'm not bragging. I'm saying that I can hear my voice start to crack. And I'm like, this is the end. Or it might be because I yelled at my kids because it was the last week of summer and it was a lot.
All right, then, Alice. Well, I'm fine with signing off. If you guys have thoughts about Kelo or red wine or singing or anything else, shoot us an email, prosecutorspod@gmail.com. Add prosecutorspod for all our social media. Check us out. Be there, be square.
That's right.
5-star review.
Thank you guys.
Leave a question.
For always listening and for giving us great ideas. Tell us what you want to hear on Legal Briefs and leave a 5-star review. You get to ask a question and we will answer it. And we, like you saw tonight, we will answer lots of questions. Brett, it's always great spending Friday night with you. All of you guys, stay safe, be good. Let us know what you think about Kelo. Maybe you're the one supporter, Sorry not to rain on your parade. Tell me why you love it. But until next time, I'm Alice.
And I'm Brett.
And this is the Prosecutor's Legal Briefs. Good cases. So the City Confidential ones, like, they're all a city, like you get to know a city. And yesterday I recorded 4 and I had lived in all 4 cities. I was like, this is a little bit creepy.
Is it going well? Are you enjoying it?
That's fine. Yeah, of course.
Yeah. You get a lot of good.
I miss you.
You guys need to go leave reviews on Apple. Leave a 5-star review for City Confidential and American Justice.
You don't need to
and leave a question,
reviews.
and we'll answer it.
I do.
Day O, Sandra Day O, Kelo come and they taking my home. Day, Sandra Day, Sandra Day, Sandra Day O, Kelo come and they taking my home. Thought the court saved my childhood home. Too bad team needs another dome. Like that. I'll tell you what I'll do. I will get the lyrics.
Please keep going. Please keep going.
I don't remember all the lyrics.
The reason I haven't said anything is I really want to hear it all. Where did you sing this song?
Poor man, little man takes the punch. Pfizer, Walmart, get free lunch. Something like that. But what I'll do, I will find...
Brett, this is how did I not know you did this and why is this not released on Spotify?
I'll tell you what I'll do. I'll find the song, the lyrics, and I'll post them. And you guys out there who are actually musically talented, you can create a version of it, and we'll release it to the public.